Hello and good day to you. My name is Karen McGirt, and I am a special education teacher. And I just wanted to go over a couple of important things that, as parents, you should know before going into an IEP meeting or any meeting with the public school. And what I want to reiterate to you or just summarize to you is the procedural safeguards that should always be relayed to you and that you should understand inside of sending your child with exceptional needs to any public school within Florida. First thing is that I like you to know that as parents or guardians of children with exceptional needs that has been deemed eligible to receive special education and related services, your rights are safeguarded by the state of Florida under federal law. The federal law concerning the education of your child requires the schools to provide you with notice and that contains a full explanation of the procedural safeguards available to you under IDEA and the U.S. Department of Education. Also, you should know that as a parent, you are afforded the opportunity to participate in all meetings regarding to the identification, evaluation, or reevaluation and educational placement of your child. The district must provide you with 10 days prior notice of meetings, and the notice must inform you of the purpose of the meeting and why the meeting is being held. Accessing educational records as a parent or guardian, you have the right to inspect and review any educational records relating to your child that is collected, maintained, or used by the district. The district must comply with a request to review the educational records without any unnecessary delay and before any meeting relating to your child or the student or the child that you have guardianship over. You must also give informed consent as a parent or guardian. Your consent must be obtained before personal identifiable information is disclosed to any other parties other than those participating agencies that are involved or part of the IEP team. And there also should be a prior written notice. This is pertaining to certain information that must be given to you in writing. Whenever the district proposes to initiate or change the identification, evaluation, or educational placement or provision of free and appropriate education of your child, you must receive written notice to all in any of those instances. 1 year prior to your child reaching the age of 18 years of age, all education rights would transfer from you, the parent or guardian, to the student, unless otherwise determined. But you should also get 1 year notice of that as well. So yeah, anything that changes with your child, you should receive some type of communication or written notice. Understandable language, independent educational evaluation. You should be given a copy of, as a parent or a guardian, of notification of conference recommendations, form the conclusion of the IEP meeting. This specifies the options considered by the team and informs you of your right to obtain independent educational evaluation, which is IEE. And if you disagree to the findings, this must be conducted by a qualified person who is chosen by you and is not employed by the district school board, right? Also, the right to stay put during a pending due process hearing. of any judicial proceedings, your child must remain in his or her present education placement with the eligibility status and special education and related services that were provided at the time of the filing of the hearing request. So your child should not be removed or switched around or misplaced by any means necessary during the pending due process hearing. So everything must stay as is until a conclusion has come regarding that issue. Despite resolution options, concerns with respect to any matter relating to the identification, evaluation, or educational placement of the student or provision of FAPE to a student should be directed to the local school district. You may file a signed written complaint with ISBE alleging that the rights of your child or several children with disabilities has been violated. It must have statement, it must have facts, it must have names, addresses of students involved, signature, and your contact info. So if there's any dispute, the options for resolution is that you provide something with basically an outline of the facts, statements of the facts, witnesses, names, address, all of that sort must be submitted. There are some other organizations, because this is just a brief summary of a couple of things that you will find inside of your the procedural safeguards and the rights that you have as parents. There is ARC is a foundation all over the United States that promotes and protects the human rights of people with intellectual and developmental disabilities. They actively support full inclusion and participation in the community throughout the years. So that is an organization that if you need more information or you would like to know more about your rights or more about resources, ARC is an excellent organization for that. Also, another organization is called Family Voices. They aim to achieve family-centered care for all children and youth with special needs. This organization focuses on providing families with the tools to make informed decisions, advocate for improved public and private policies, and build partnerships among professionals and families within the community. So I hope this little bit of information helps you as a parent know where you stand and understand that your rights are safeguarded. You and your child's rights are safeguarded. And the school that your child attends should let you know and let you fully understand all of your rights as a parent, as a guardian of a child with special needs. So any school that you go to, you can ask for a copy. If you haven't received it, you can ask for a copy of the procedural safeguards, and all these things and more are outlined in that document. Thank you for listening.